Peace of mind, what that means is giving it my all, not leaving anything, no stone unturned. I can sleep better at night even when litigation, you don't know what the outcome is going to be, when I did everything that I could to get a good result for my client.
Welcome to the Verdict Signal podcast, where we feature how top attorneys help people make informed choices, avoid common mistakes, and move forward with confidence. Now, enjoy the show, and here's your host.
Daniel Gao here. I'm the host of Verdict Signal, and today we're expanding our conversations to the experts who protect what people build, their careers, families, and businesses. I have Rafael Lazaro, the founding partner of Lazaro Law Group, a boutique employment law firm based out of Chicago. Over a career spanning more than 25 years, including stints at powerhouse firms Seyfarth Shaw and Stoll and Friedman, he has recovered over millions of dollars for workers facing harassment, discrimination, retaliation, and wrongful termination. He is one of a select few attorneys who litigates employment matters for both employees and employers, and in both English and Spanish, giving him a unique perspective on workplace justice in diverse communities. He's also been a super lawyer for the last 8 years. So Rafael, welcome and glad to have you here.
Oh, I'm happy to be here. Thank you so much, Daniel, for the invitation.
Yeah, so let's start at the very top level, Rafael. How did you first get interested in the legal field?
I remember it as if it was yesterday. My grandfather was a lawyer and a judge, and I used to spend the summers with him. So I remember distinctly one day he had his office in Old San Juan. I'm from Puerto Rico. He took me to his office, and then we walked right across to the federal courthouse. We went into the courthouse, and I was immediately, attracted to the field because of what I saw, right? I couldn't understand half of what was going on, but I knew I wanted to be a lawyer right then.
Okay. And what led you to focus specifically on employment law?
Well, employment law in Puerto Rico specifically, you don't have a right to a jury trial for the state in state court. So that means that most employment cases go through the federal courthouse because lawyers want to litigate in front of a jury these particular cases. And I, after graduating from Cornell, I did a federal clerkship, and I wanted to practice in federal law. And I asked the judge that I was working for, where if I wanted to practice in federal law, in federal court, what I should do. And he said, well, you can be a prosecutor, or if you want to be in the civil side, consider employment law, because most cases are prosecuted through the federal system in Puerto Rico. So that's how I ended up as an employment lawyer.
Got it. Okay.
Yeah.
Now, Rafael, what's one thing you really kind of wish more people understood about working with an attorney? Because I'm sure you know the joke of how people view lawyers in general. But what do you really kind of wish people understood about working with lawyers, working with attorneys?
And this happens so frequently in my cases, and I hate it when it happens. Finding facts later on, when we should have heard about them at the beginning of the relationship. I wish people understood that, any communication with an attorney where you are seeking legal advice is protected by the attorney-client privilege. And if a lawyer is going to provide you their absolute best representation, we should know all facts, right? Some people, think that if I just leave this out, I'll be in a better place, where it actually is the contrary to that. It's much better if we know everything, so that we can deal with it in an effective way rather than being surprised later on. So being honest with your lawyer, um, putting all your cards out there leads to a much better place than trying to hide or leave out facts that don't necessarily are good for your case.
Okay. So I guess they need to
Yes.
kind of view working with the lawyer or look at the lawyer as you are their experienced, knowledgeable representative representing them. It's not like you are necessarily, I don't know how to put this, but like you're not like the enforcer of the law where if they did something wrong, you're going to get them in trouble. It's that you need to know
No,
other things
absolutely.
to help them
Yeah,
and be the representative
absolutely.
first.
It is much better for me to know what my weaknesses are from the very beginning,
Mm,
because I can work with the weaknesses rather than being surprised along the way and then don't really have an answer to them. And believe me, those facts will come out. The discovery process is robust in these types of cases. So that means that if you are hiding something, we will, it will come up. Even if you wrote an email and then deleted it, um, you know, the other side, if they're really interested, can get it.
mm,
So don't hide facts. Be honest. That is the absolute best policy.
Okay, good to know. Now, when it comes to the common situations that your clients come to you for, I know that there's a lot of things that you do. I just mentioned in your introduction that you help people with harassment, discrimination, retaliation, wrongful termination. But what would you say is the most common situations that clients come to you for?
For me personally, I get a lot of calls from female clients,
Mm,
either gender discrimination
mm,
or sexual harassment. Um, the things that I hear, you would think that we are in 2026,
mhm,
and that the that employers have learned along the way, but the things that I hear constantly
mhm,
is that we're still so behind in really offering people the best, the absolute best, um, you know, employment arena that they can have. We end up in situations where there's a lot of abuse,
mm,
um, in terms of females in the workplace,
mhm,
um, much more than people would think. The other area that I get a lot of calls on is disability cases.
mm,
People do struggle with medical issues,
mhm,
and there are rules in terms of how employers should deal with those. And employers do get in trouble if they don't follow those rules, and many of them don't even know how to start,
yeah,
right?
yeah.
So in terms of disability, somebody gets sick, somebody gets cancer. We just settled a case last week, where there was a woman who, had an unfortunate, medical situation. She got cancer, and instead of helping her, they ended up firing her under the premise that she couldn't do her job.
Mm,
Well, that's not going to look good in front of a jury,
yeah.
right? And people do understand cancer
Mm,
and do understand, whereas in other types of discrimination, if I'm not of a particular race, I might not understand.
mm,
Um, but people do understand medical issues because we all are exposed to it, right? So those are the two main cases that I personally see a lot of.
okay. Now, the script,
Mhm.
disability discrimination, that was actually surprising. Like, I would have never thought that disability is like, oh, they get cancer, and then like they get rid of them because of the cancer. I would have never thought of it
Yeah.
that way. I would have just thought like disabilities, like, oh, they're in a wheelchair or like something like that, and then they're being discriminated against because they're in a wheelchair. But I would have never thought that getting an illness could also fall under disability discrimination.
Oh, absolutely. And we see a lot of mental disabilities too.
Hmm.
Those are even trickier, right?
Mm-hmm.
People who have anxiety or people who have, depression,
Mm-hmm.
and how that can be accommodated at work.
Mm-hmm.
Or maybe there's situations where you can't really accommodate them at work, right? Um, but yeah, there's certain things that the employer can do to accommodate those people, to to enable them to do their job anyway.
Yeah.
After the pandemic, we got a lot of
Oh,
people
yeah.
saying, I want to,
Mhm.
if I only work from home,
Mhm.
I may do my job effectively from home.
Mm.
Um, it used to be that the employer could always say, no,
Mhm.
you need to come to the office to do your job. That
Yeah.
that is no longer the case, right?
Yeah. Okay. Now, with the sexual harassment, I want to go back and revisit that one because I'm sure you've gotten situations where clients come in and they basically said that, oh, like, and you asked them how long has this been going on for, and they probably said that, oh, it's going on a long time. I just didn't think it was sexual harassment. I thought it was just they were joking. I thought it was what's that serious. So I guess where's that line where it is considered sexual harassment? And I guess outside of the obvious, oh, this is obviously sexual harassment, what could be some other situations that falls under that umbrella of sexual harassment that people may not normally think that, oh, this actually is sexual harassment, kind of like with the disability discrimination. I would have never thought that cancer would fall under that, but it
Yeah,
does.
for
So like
sure.
on the sexual harassment side, like what do you like kind of define that a little bit easier? I think some people don't necessarily know where that line is outside of the over, oh, this is obviously sexual harassment.
Well, there are two general types of sexual harassment, right? The first one is easier to understand. That's quid pro quo,
Mm-hmm.
which basically means this for that.
Mm-hmm.
Basically means, hey, I'm going to exchange one thing for another one. It is the manager who is the keeper of the purse, right? Who is the person who can provide something to the employee,
Mm-hmm.
and they might say, hey, I'll give you, X position, or I make sure that you are in line for that position, or I'll give you a good evaluation if you go out with me on Friday night. You know, that
Mm-hmm.
is the exchange for one thing of the other one. That is clearly sexual harassment, right?
Mm-hmm.
The other is the hostile work environment claim.
Mm-hmm.
The most egregious is when there is an unwanted touch at work,
Mm-hmm.
right? A forced kiss, a forced embrace. Those are the more egregious parts, right? But then there are the other ones that fall in the gray areas,
Mm-hmm.
right? And ultimately, who decides whether it's sufficiently severe and pervasive, which is the words that are used by courts to figure out if they if this harassment, is sufficiently is illegal, is whether it's severe or pervasive, right? So ultimately, it is a jury who figures that out,
Mm-hmm.
whether that is sufficiently severe or pervasive. There are some cases that are not going to hit that. If it's one joke, even if it's of a sexual nature,
Mm-hmm.
that joke is not going to be sufficient.
Mm-hmm.
Right? That's called a stray remark.
Mm-hmm.
Now, if it's done every day
Mm-hmm.
by the same manager, and if it's of sexual nature, yes, right? So it's hard. There's some cases where it's hard to draw the line, but
Mm-hmm.
that's why we have a jury who looks at the totality of the circumstances to figure it out.
Okay. So now, when it comes in this topic, are there any other kind of common misconceptions people have? Like we kind of talked about the sexual harassment side, like kind of where do you draw the line? On the disability side, we talked about having cancer, and that falls under disability discrimination. Are there other kind of common misconceptions that you see either your clients or people talk about, like, oh, I didn't know that.
Yeah, well, a common misconception is that, and I see this, many, many, many times. People come to me and they are convinced that they have a case, right? And I always have to explain it's not about what happened. It's about what I can prove in a court of law. Are completely two different things,
Mm-hmm.
right? You can have the best case in the world, but if you can't prove it, a lawyer like me is not going to invest time and money in that case, because what matters in front of a jury is what you can prove,
Mhm.
right? So those are different animals. You know, the other big thing in employment cases is, and in any type of case, there are two parts of the case. There's one that's liability, whether I can prove that there was a violation of law, and number two, and very important in certain circumstances, is can you recover? You know, there are many situations where you have liability, but at the end of the day, you know, you have a defendant that doesn't have money. And, you know, those are unfortunate circumstances where, you know, an employment lawyer like me is not necessarily going to be, want to be involved in a case where ultimately you can't recover.
Mhm.
But a common misconception is I have the best case in the world. Okay, but let's look at the evidence,
Mhm.
right?
Yeah.
In many occasions, the evidence is just not there.
Mhm.
Even though you were mistreated, and I know that you were mistreated, what evidence do you have to prove it?
Got it.
Two different things.
Yeah. Okay. That's really good to know then. Now,
Mhm.
what would you say then, Rafael, are some of the biggest mistakes people make before they call a lawyer? Like they have this case
Yeah.
of sexual harassment or disability discrimination or retaliation or whatever it is. What are some of the biggest mistakes people make before they call a lawyer?
Well, for a sexual harassment case, um, and any discrimination case, you have to complain to your employer.
Mhm.
You know, the law does require you to make an internal complaint of discrimination or harassment, because you have to give an opportunity to the employer to ensure that, you know, that they take action to ensure that they stop the harassment.
Mhm.
If you don't give that opportunity, the employer is going to have what's called an affirmative defense. Okay, so many people, what they do is, you know, they fear retaliation,
Mhm.
um, and because of that, they fail to complain, which unfortunately will lead to a case that's really difficult to prosecute.
Mhm.
Um, another, you know, uh, not reaching to a lawyer, not reaching out to a lawyer, um, timely reaching out to a lawyer. You know, there's tons of things that the lawyer can do before you get fired. You know, giving you advice. I give a lot of advice to current employees, um, as to how to protect yourself and to have a cognizable claim later on.
Mhm.
So trying to do it by yourself usually leads to a bad result.
Mhm.
Um, you know, people who post things in social media,
Mhm.
you know, that's damning,
Mhm.
a lot of the time.
Mhm.
Um, so not reaching out to a lawyer, not complaining internally, and trying to take matters into your own hand, I think are some of the biggest mistakes people make.
Okay. Now, on the flip side of that, what are, if they are facing some type of harassment or discrimination, what are a few smart steps that they can take first? So, I mean, obviously, it's kind of the flip side of what you just talked about, but what are some other ones that maybe we didn't talk about yet, but some of those smart steps they can take in the beginning?
I think that one thing that they can absolutely do is make sure that they have the right documentation. You know, juries uh, uh, do like seeing things in writing. You know, you can talk about things and testify about X or Y happened, but they want to see the paper trail.
Mhm.
So not even if it's on your own personal, you know, notebook. Um, don't use the employer's computer, because you don't know until, or um, you know, not taking abilities or whatever the app. You know, you should use your own,
Mhm.
because you don't know when that is going to go away, right?
Mhm.
So make sure that you document appropriately. um, things that are going on, and you document it the day of the event, right? Because memory, you lose a lot of evidence through the passage of time. Whether it be, the identity of documents, the identity of witnesses, what specifically happened. So yeah, I think the biggest thing that a potential plaintiff can do is to document appropriately. Yeah.
Okay, really good to know then. Now, Rafael, let's say that somebody is facing these situations and they know they need help from a lawyer, but they don't know who to choose. They don't know any lawyers, and there's lots of lawyers out there. What advice could you give to this person as they do their search so that they can find that lawyer who is knowledgeable, is experienced, and can pretty much help them in the end?
Yeah, and that's something that I say to everybody that talks to me. You should talk to somebody else. Go out there and talk to as many lawyers as possible, because this is, if your matter goes to litigation, you're probably going to have a relationship with that person for years. And if you don't get along with that person, that is a problem. Right? So the first advice that I give is go out there and talk to other people. Different lawyers have different ways of looking at things, right? You should know, first of all, how many lawyers has that lawyer been practicing? You shouldn't, give your case to a lawyer that has been in the practice for 2 years. You should find somebody that has specific, that has dealt with your type of case specifically. And in what industry, right? That's important too. Have you dealt with this industry in the past? This type of case in this jurisdiction? Sometimes I get calls from somebody was employed in Florida. I've never dealt with a case in Florida, right? So I'm going to pass that on, right? So it's important to know how many years the lawyer has been practicing in your area, whether the person has dealt with the specific industry that's involved and the specific case you have, right?
Okay, really good advice there.
And also, if you have a law firm that mine, I have 5 lawyers working for me. Who's going to deal with my case? Is it going to be you, or is it going to be somebody else? And if it's going to be somebody else, why is this person not in this meeting, right? Yeah. You should get to know that person.
Okay.
Right?
Yep. Very good to know. So great advice for people who are looking for a lawyer. Now,
yeah.
Rafael, I know that setting expectations is really, really important, especially when it comes to law, especially when it comes to this. You kind of mentioned before that people know they've been discriminated against or they face some type of wrongdoing, but if it can't be proven, then it doesn't really matter. So
right.
How do you set those expectations so that your clients feel informed and supported throughout the process?
Yeah, absolutely. I think I'm an open book. I am going to tell you what the good things are about your case and what the not so good things are about your case. Because once you're in litigation, anything can happen. I have seen cases where I thought that we had a great case and we end up not being successful. Oh, and the contrary has happened too, when I think that the case is not that great and we hit it out of the ballpark. So, it's important to understand that once in litigation, anything can happen. We can prepare as much as we can. I always say this to my lawyers, which is the 5 Ps. Proper preparation prevents poor performance, right? We can prepare you as much as we can, but sometimes even with that preparation, a person gets nervous and they throw away their case in a deposition. That happens more than I would like it to happen, right? I make sure that people understand the good things about the case, but also their weaknesses. And I go back to my original point: when people are not completely honest, finding out about a weakness halfway through the case puts me in such a bad position to actually be successful.
Okay.
Mhm.
Really good to know on that one then. Now, Rafa, I'm sure that
Yeah.
throughout your experience, there have been some memorable cases or even challenging cases. I mean, you kind of talked about some of the cases where some you thought is really good, but doesn't turn out so well, or some is you don't think is that good, but turns out really, really well.
Yeah.
There's maybe one story that you can share of one of these memorable cases, and how you're able to get a successful outcome in the end.
Yeah, I mean, and this is not an employment case. The most memorable case is a case here in Chicago. We sued the Chicago Public Schools. It was a severely disabled child who was raped by another child during school hours in the
Wow.
school bathroom.
Hmm.
So even though that seems like something that should lead to liability, the reality is that the law is very hard, because since there was another child involved, the problem is that you have to, it's a criminal act by a third party, and whether you can make responsible the school for the criminal act of a third person, right? So even though we had a lot of potential to lose the case, we survived all the dispositive motions, and we ended up in trial. We had 3 experts testify, including one on liability, and multiple experts on damages. And we end up settling the case for more than 7 figures.
Wow.
So for a family who, with very limited resources, it was a really, really good outcome. That child is going to be taken care of for the rest of his life, right?
Yeah.
Somebody who really needs it. So
Oh, yeah.
that was trying in case in front of a jury was really intense. But we were under very difficult circumstances. We were able to be successful.
Wow. Yeah, I could see why that's a memorable one. Wow, it really
Yes.
stands out. Okay, now, Rafael, when it comes to the future, do you kind of see any changes in employment law? I guess anything that people should really kind of pay attention to?
Yeah, I mean, this particular administration has kind of turned things on its head. The federal agency that administers employment discrimination cases, it's called the Equal Employment Opportunity Commission. They're no longer interested, for example, in what we call disparate impact claim. They're not litigating disparate impact claims. And now what they're doing is litigating cases, basically more cases for white males, more than minorities. So that's something, that agency has basically gone away. So we can't use it anymore, which means that the states are taking the grunt of the work now. The other, aside from the EOC being now an agency that really doesn't protect minorities anymore, the advent of AI, I think, is something that is really having an effect on the law. In Illinois, there is a law now saying that if the employer is to use AI for any employment decision, they gotta notify the employee, which is really, really interesting, right? And they're watching out also for, AI can lead to discriminatory effects. So you can't really use AI and feel comfortable for hiring, stuff like that, because it could lead to discrimination.
Wow, that's going to be very interesting to see what happens there then.
Yes, for sure, because people are going to use it anyway.
Oh yeah. Okay. Now, with the future in mind, Rafael, I want to see what is your how do you kind of see your practice? What's the vision you have for your practice?
Well, we've been hiring a lawyer every 2 years or so. And the vision that I have for my practice is a place where, first of all, each lawyer gets to develop their practice the way that they want to. Each lawyer gets to choose the cases where the law firm is going to invest. So if a particular lawyer of my firm has an interest in wage cases, then the firm will invest in those type of cases, or pregnancy cases, for example. Then the firm will invest in trying to get those type of cases, right? But it's also a firm where we prioritize our time off from work. To me, that's extremely valuable. Where we have each other's backs. And if you need to take some time off, or if you get your vacation, but you can take as much time as you want to, as long as the work is being done, right? And we will back you up. Also, it's a firm where there is no hierarchy in terms of everybody's opinion counts. It doesn't matter if you're the lower level employee or me, right? Everybody's opinion counts when we're making decisions. So I'm trying to give my lawyers a place where I didn't have, right? Which is a place where they get to prioritize their family and balance that out with how we make a living, right? We're really blessed with really taking something terrible that happened to a person, perhaps the worst day of their lives, right? Or the worst thing that has happened to them, and trying to make something positive from that, right? So making a living out of that, I think we're really blessed.
No,
being able to do that.
Vision. Sounds like a wonderful vision for the practice.
Yeah.
Okay. Well,
so doing it with kindness, it's important for me that all my lawyers understand that, empathy and kindness is extremely important for the work that we do.
Well, very well said. Okay. Well, Rafael, I have one last question for you, but before I ask it, I do want to point people to your website at lazarolawgroup.com. Now, last question is, what does peace of mind mean to you?
Peace of mind, what that means is giving it my all. Not leaving anything, no stone unturned. And really, I can sleep better at night even when litigation, you don't know what the outcome is going to be. When I did everything that I could to get a good result for my client. That's peace of mind, right? Sometimes you can't control the outcome, but what you control is how much you put into it.
Okay. Well, there you have it. Rafael sharing his expertise. So, Rafael, where can people contact you and your practice?
The best way to contact us is going through our website. We have a questionnaire that will enable us to, start the process. We try to get back to you within 48 hours. So the best way is to go to our website, lazarolawgroup.com, and fill out that questionnaire. We get back to people as soon as we can within 48 hours.
Okay, awesome. Well, this is great. Thank you, Rafael, for coming on. Thank you for sharing your knowledge, and thanks for sharing your expertise.
A real pleasure.
Thanks for listening to the Verdict Signal podcast. Any questions? Please contact the practice directly with the contact information provided during the show. We'll see you again next time. Bye for now.